Welcome, everyone. My name is Eric Ashcroft. I am the incoming Symposium editor for the George Mason Law Review, and I'd like to welcome you to this morning's panel on the revival of the Robinson-Patman Act. And today's moderator is Professor Kobayashi, who is the Paige V. and Henry N. Butler Chair in Law and Economics here at Scalia Law. So, Professor?
Thanks, Eric. I was walking my dog this morning, and a lot of the ice had melted along the side of the road, and he had been very interested in sniffing lots of things, just incredibly interested. And I thought, yeah, that's like Robinson-Patman. You know, it's like long frozen and dormant, and now it's things are warming up, and we're going to do this again. It is really an extraordinary thing that we're doing a panel on Robinson-Patman. I was talking to my colleague Tim Uris, who will be on the panel later, and I said, would you have guessed that in 2026 we'd be doing an RPA panel? And Tim said, yeah, of course. We have a great panel together. Up on the screen, we have Dan O'Brien, who is snowed in Truckee, California, I guess. And Dan sent me an email recently saying that he was going to have trouble getting here, and I looked and I said, the Palisades, which used to be Squaw Valley or whatever up there, had how much snow? Like 20 feet? But anyways. So Dan's going to start us off and talk about the economics of intermediate price discrimination. We'll then hear from John Nuechterlein, who will give us a little short RPA primer and get us going on some of the old history of the Robinson-Patman Act and its enforcement. Next is Mark Poe, and he's going to be talking about private litigation, some that he has been the lead counsel on, and generally talk about Robinson-Patman over sort of both recent times and prior to that. And finally, we'll end with Alden Abbott, who will talk about things going forward, and maybe talk about some of the recent cases brought by the FTC, Southern Glazer, and the Pepsi. Anyways, I will step aside and get us going, and we'll start with Dan.
Good morning. First, I want to thank Bruce and the organizers.
So Dan, we can't hear you. Don't. Yeah.
Go ahead, can you test?
First, it looks like to me, I think
Can you guys hear me?
Oh, yeah.
Yes.
Here we go. All right, great.
We're on?
You're on.
All right. Should I take it away?
Go ahead.
Good morning, everybody. First, I want to thank Bruce and the organizers at the Law and Economics Center for inviting me to participate in this symposium to talk about a topic I've been interested in and involved in over the years. I'm sorry I'm not there in person. You may have read about the avalanche. That actually occurred just a few miles from my house. And the same conditions made it hard to get to the airport. So here we are. Hopefully technology will work. So we're discussing a question that has existed in competition policy for almost a century. When suppliers charge different wholesale prices to different retailers, should antitrust law intervene? The concern's familiar. Large buyers, maybe supermarkets, platforms, big chains, they obtain discounts that smaller rivals can't match. Smaller firms, often claim this weakens competition, and of course, policymakers feel pressure to act. So in the United States, this led to the Robinson-Patman Act in the 1930s, which was designed to protect small retailers from chain stores. The law has been heavily criticized for decades. Most of that criticism focused on final consumer markets. But the real difficulty is that most of the action actually occurs in intermediate markets between suppliers and retailers or downstream intermediaries, and the economics there is very different. So in my remarks today, I want to explain why that is and talk a little bit about the economics and what it means. So let's start with the standard intuition about price discrimination and why that intuition is incomplete. Economists traditionally analyze third-degree price discrimination, a buzzword coined by Pigou, as a seller charging different linear prices to different buyers. So in final goods markets, it turns out that the welfare logic is reasonably straightforward. In linear demand environments, if price discrimination does not increase total output, it typically reduces welfare. So under linear demand, what happens is output doesn't change, but discrimination harms welfare because it creates a distortion. So that reasoning motivates suspicion towards discriminatory pricing. But intermediate markets where price discrimination that the Robinson-Patman Act addresses operates, they differ from final good markets in three important ways. First, buyers compete with each other, so demand from the different buyers is interdependent. Second, prices are negotiated often rather than posted. And third, contracts between the seller and the buyers are often nonlinear. They often involve rebates, slotting allowances, quantity commitments, and so on. So once you introduce bargaining and downstream competition and these other complications, the standard conclusions become unreliable. So let me start with, there's a classic intermediate product price discrimination result that motivates some of the reasons why we might want to forbid price discrimination, even in intermediate markets. And that was in a model presented by Michael Katz almost 40 years ago. He looked at a monopolistic supplier selling to competing retailers where the large retailer had a credible outside option, backward integration, and it was able to use that option to get a lower wholesale price. So the result that he found was striking. If that threat of integration is not exercised in equilibrium, it doesn't occur, then forbidding price discrimination increases output and welfare. And it can actually do this by raising prices charged to all downstream firms, large and small. So this was important because it suggested that protecting smaller firms by forbidding price discrimination might sometimes align with efficiency, not just redistribution. But the mechanism that Katz identified depended heavily on a specific source of bargaining power, the large firm's credible threat to pursue an outside option. And that turns out to be a key limitation. So what happens when bargaining power involves more than outside options? In real negotiations, where downstream firms are bargaining, trying to get discounts, bargaining strength comes not just from the threat to walk away and integrate. It comes from four sources: disagreement profits, bargaining weights, concession costs, and outside options. Okay, and this is sort of standard Nash bargaining. So in most retail negotiations, bargaining power is driven a lot by concession costs, the losses incurred when negotiators move away from mutually beneficial pricing terms. When you adjust price, there's a concession cost, and that affects your bargaining strength, not just the integration threat. So when we incorporate that fact and other factors relevant in bargaining into a bargaining framework, which I'm borrowing from my own work here some years ago, the conclusions change quite a bit. In a Nash bargaining model between a supplier and competing retailers, something counterintuitive comes up. Even if a large chain receives a discount, that discount can lower overall wholesale pricing pressure and intensify downstream competition. In particular, if the discounts arise from bargaining advantages from sources other than integration threats, forbidding price discrimination often raises the average wholesale price. Welfare can fall when discrimination is banned. So the intuition is pretty subtle. Discriminatory contracts create what economists call contracting externalities. When a supplier negotiates separately with multiple retailers, each negotiation affects the competitive position of the others. Those interactions dissipate rents, and they tend to push retail prices downward. Uniform pricing removes that mechanism. So ironically, a rule intended to protect competition can actually soften it. And this does not disappear when retailers compete very intensely. The effects are still there with strong downstream competition, and in fact, the effects can be even stronger. There's actually evidence consistent with bargaining rather than coercion or other factors driving where prices end up. Historical evidence aligns better with the bargaining interpretation. After the Robinson Act was passed, major grocery chain stock values fell. That's consistent with chains losing bargaining leverage. And earlier empirical observations showed that branded suppliers benefited from the law, and that's also consistent with the bargaining models rather than the simple take it or leave it pricing formulation of price discrimination. So the data does not obviously support the idea that discounts are bad rather than good. Nonlinear contracts, so far I've discussed linear pricing or per unit wholesale prices, but real supply agreements rarely look like that. As I mentioned, they often include volume rebates, slotting allowances, sometimes retroactive discounts, sometimes two-part tariffs, just generally volume-related discounts. When bilateral negotiations over nonlinear contracts is possible, even though the analysis is more complicated, the results can actually sharpen. If price discrimination is allowed, wholesale prices can equal marginal cost. And if discrimination is forbidden, wholesale prices rise above marginal cost and welfare falls in most cases under bargaining. So in other words, banning discrimination often creates double marginalization, and that's the very inefficiency that antitrust policy usually tries to eliminate. So what is the broader policy implication from the discussion so far? Both linear and nonlinear contracting models with bargaining share a common mechanism. Bilateral contracting increases competition because negotiations impose externalities across downstream rivals. Non-discrimination rules remove those externalities and can soften competition. So when we combine this with situations without bargaining or with bargaining driven only by outside options, as in Katz's model, we reach a general conclusion. There is no universal welfare ranking between discrimination and uniform pricing. But in intermediate markets, forbidding price discrimination can easily cause harm. That said, the conclusions from the literature on final goods in linear price environments, they remain relevant for settings without bargaining, though it's nuanced by the existence of downstream competition. But anyway, the general lesson from the literature is that sometimes bans help, but sometimes they substantially harm welfare. There's no general prediction. So what does this mean for policy? Being cautious here, I mean, it brings us back to the original concern. Large buyers are receiving discounts that smaller buyers can't obtain. Economic theory does not say that we should ignore this, but it does say something important. Harm to competitors is not reliable evidence of harm to competition. In intermediate markets, discriminatory pricing often reflects the mechanics of bargaining, not exclusionary or other harmful conduct. So a general prohibition risks targeting a symptom rather than a problem and may reduce consumer welfare. So let me close and maybe if we have a discussion, leave for discussion. I want to make the takeaway here is that a policy that prohibits price discrimination, it may protect small firms in some settings and could protect consumers in some settings, particularly where outside options drive bargaining. But in many realistic contracting environments, it raises prices and weakens competition. So the right question is not really, is price discrimination unfair, but rather, what mechanism is generating it? And I'll stop there, and if there's a discussion, there's a harder question, which is how we should operationalize that distinction. And my personal view is that we probably shouldn't, but we can talk about that later. Thank you.
All right. Thank you, Dan. We'll go to John.
So first I want to thank the Law and Economics Center as well as the Law Review for the opportunity to speak here today. So for many years after I decided to become an antitrust lawyer, I held out hope that I'd never have to learn the details of the statute that we're discussing this morning. That 1936 legislation is notoriously counterintuitive from an economic perspective. It's also sort of Byzantine in its complexity, and so I took some comfort in the fact that, at least as long as I've been practicing law, the antitrust agencies in the federal government have not been pursuing Robinson-Patman Act cases because they soured on it in the 1970s, concluding that it was likely to be on balance in anti-competitive law. Those days are now over. Because everything old in antitrust is cool again. The Robinson-Patman Act is back in political favor, and you ignore it at your peril. So to understand it, let's go back to the beginning. 100 years ago, there's a single company that radically disrupted the retail sector in the United States, and it created very important political enemies along the way, enemies that would then later go on to enact the Robinson-Patman Act. That company was a vertically integrated supermarket chain named A&P, which was by far the largest retailer in America, and it relentlessly undersold its smaller grocery store competitors. Side personal note, my first real job in high school was as a bag boy at the A&P. So I have some fondness for this company, although by the 1980s, that company was in mortal decline. So how did A&P transform the retail landscape? A couple of important economic factors. First, because of its scale, A&P had bargaining power, and it negotiated lower wholesale prices than the corner grocery store could negotiate. And A&P had also vertically integrated into warehousing and distribution. And that enabled it to avoid having to pay the wholesale middlemen that usually stood between food producers and consumers. A&P passed these upstream savings on to consumers in the form of lower prices in its stores, and corner grocers couldn't match the lower prices. And so this obviously benefited consumers, but it obviously harmed the corner grocers, and it harmed the wholesalers who were serving the corner grocers. So the Robinson-Patman Act of 1936 was enacted in large measure to undermine AMP's successful business model. And no surprise, it was originally called the Wholesale Grocers Protection Act. So let's quickly review the Act's working parts as they relate to so-called secondary line price discrimination, which is the focus of our discussion today. So, in general, the Act forbids suppliers to sell commodities of like grade and quality, it's a statutory phrase, at different prices to different purchasers if doing so gives one purchaser a competitive advantage over another. The Act also comes with a variety of qualifications and affirmative defenses that respond 90 years of intractable litigation disputes. First, the Act applies only to sales of tangible products, not services, and only if the goods qualify as interstate in the sense that they can be said to cross state lines. Now, that requirement has raised all sorts of disputes about how you handle scenarios in which goods are manufactured in one state and then shipped to a warehouse in another state and then eventually sold to the latter state's purchasers. Second, a supplier that provides special discounts to a given purchaser in violation of the main rule can escape liability if it proves that it acted in good faith, quote, to meet an equally low price, unquote, of a competing supplier. But this affirmative defense permits the supplier only to meet, not to beat, the lower price offered by the customer's alternative supplier. It also requires defendants, as a practical matter, to substantiate their prior knowledge about their own competitors' prices. Well, so what's the result of that? That requirement, de facto requirement, creates perverse incentives for all the relevant actors to share what would otherwise be non-public information, and with a potentially anti-competitive effect of stabilizing prices. Finally, another affirmative defense enables a supplier to escape liability if it proves that price differences track, quote, differences in the cost of manufacture, sale, or delivery by the supplier. In practice, this is a difficult defense to substantiate. Litigation on the issue, in the words of one Yale professor in 1937, quote, proceeds by the ordeal of cost accountancy. Opposing experts will argue about such economically intractable issues as the proper way to allocate joint and common costs across different transactions. Okay, so let's return to the Act's core ban on wholesale price differences and the immediate effects on the A&P supermarket chain and other chain stores in the 30s. So before 1936, A&P could bargain aggressively with farmers, other food producers, for company-specific discounts on, let's say, eggs. And then they could pass the savings on to consumers in whole or in part. After 1936, after the Act was enacted, a farmer had to charge A&P the same price per egg that it charged smaller grocers or their wholesale suppliers. And that requirement plainly benefited small grocers and wholesalers at the expense of A&P. But what was the likely result for consumers? Now, the answer to that question, as we've heard and we'll continue to hear on this panel, is very complex, and it is market dependent. That you cannot make categorical claims that the Robinson-Patman Act always deserves consumers or that it always harms them. But in all likelihood, in my example, the newly uniform wholesale price of eggs was probably higher than what A&P could have bargained for, and maybe it was somewhat lower than what a small grocery store would have paid in a market with differential pricing. We don't really know. It depends on a lot of different economic variables. So though you have this new uniform price that's above what A&P would have paid and below what other buyers would have paid, that would be good, obviously, for the consumers who shopped at these smaller grocery stores. But those benefits came with a major trade-off, because Robinson-Patman, in that context, indisputably exposed A&P and other large retailers to higher wholesale costs in a range of circumstances, which such companies then pass through to consumers in the form of higher retail prices. And as a result, the most price-sensitive consumers, the ones with the tightest budgets, who came to A&P looking for the best bargains, were likely the ones that paid more for eggs, all else held equal. So sometimes the Robinson-Patman Act can have the effect not just of deserving consumers in the abstract, sometimes it has the effect of deserving the most price-sensitive consumers. Now, these complex consumer welfare considerations, the important point is that they didn't really matter to the people who framed the Robinson-Patman Act. Consumers were not the objective of the act. The act focused not on consumers, but on preserving the profit margins of smaller businesses, even if doing so leads to higher retail prices at the expense of consumers. Now, that said, it might well be the case, and we heard this a minute ago, that in some markets, Robinson-Patman enforcement just happens to create net consumer benefits alongside the intended benefits to small business. But those benefits are episodic, and they are incidental to the protectionist objectives of the Act. And they are very likely more than offset in the aggregate by the Act's upward retail pricing pressure in other markets. In any event, that was the conclusion of an influential 319-page report issued by the Department of Justice. Not in the Reagan administration, not in the Bush administration, but during the Carter administration in 1977. DOJ, in this report, placed the Act squarely in its historical context. It observed, quote, "The Robinson-Patman Act is a piece of Depression-era legislation." And DOJ went on to observe that it resembled the National Industrial Recovery Act, another New Deal law, which sought to boost employment by eliminating cutthroat competition and stabilizing prices at higher levels. DOJ's report also concluded that Robinson-Patman, like that Depression-era statute, likewise served in many markets to raise consumer prices. DOJ also made another comparison, which was to a more recent experiment with government intervention in markets. This is 1977. The country just had its experience with the Nixon administration's wage and price controls. So DOJ said the Robinson-Patman Act shares some similarities with the wage and price controls of the prior years. It noted the government tampering, I'm quoting, "government tampering with the market can lead to unforeseen results which have an adverse effect on workers, businesses, and the consuming public." So I don't want to leave the impression that DOJ's report in 1977 was the first critique of the Robinson-Patman Act. It was preceded by a lot of academic commentary on the Act, much of which concluded that the Act was on net anti-competitive and should be repealed or significantly modified. But DOJ's 1977 report did crystallize widespread opposition to the Act in antitrust policy circles. And the results were immediate and striking. DOJ stopped enforcing the Act. The FTC, which had brought thousands of Robinson-Patman claims up to that point, slowed the volume of those claims, those cases, down to a trickle, and stopped enforcing the Robinson-Patman Act altogether by the end of the 20th century. Now, of course, non-enforcement by the federal government doesn't mean that the Act itself has fallen into desuetude. Quite to the contrary. It just means that the private plaintiffs' bar has brought nearly all Robinson-Patman Act cases over the past 50 years, sometimes with great success. And we're going to hear about that from my co-panelist, Mark Poe. But now here's the breaking news for Mark and others in this field. Federal enforcers want back in the game. Lenecon's FTC brought two very high-profile Robinson-Patman cases towards the end of the Biden administration. One of them remains alive and kicking with no end in sight. This is the one against Southern Glazers. Just last month, lest you think that that Robinson-Patman enforcement is the creature of the populist left, just last month, 6 Republican senators urged both the FTC and DOJ to start bringing more Robinson-Patman cases to support the interests of those senators' various constituencies. Now, this all makes good political sense. Populists on both the right and the left view Robinson-Patman litigation as an important weapon in their fight against what they perceive as excessive market concentration at the retail level. So you should stay tuned for more litigation. But here's my word of advice to all the George Mason students and other young lawyers in the room. You might not like the Robinson-Patman Act. You might think that is very badly drafted. You might think that it contradicts the consumer-oriented thrust of the main antitrust laws. You might find its jurisprudence Byzantine and mind-numbing. But you better bone up on the details anyway, because federal Robinson-Patman enforcement is back.
All right. Al? Mark?
Thank you. So I first learned about the RPA while I was working at Morrison & Foerster. I came interested in it, started reading all the precedent during my commute, and then I started looking around and seeing what appeared to be price discrimination just pervasively. And so I got the idea with a law school classmate to start this law firm and pursue RPA cases, among other things. So we started in 2014. We filed our first RPA case in 2015 against the makers of 5-Hour Energy, and we've gone on since there. We do a mix of other business litigation and some class actions and stuff like that, but we've always had one or more RPA cases. We've done maybe 7 to 8, maybe 9, including in 2022, we filed a class action on behalf of independent liquor stores against a company called Southern Glazers, the country's biggest liquor distributor. The FTC then filed a follow-on case to ours. For some reason, no one has ever given me any credit for this. The FTC, when they filed theirs in 2024, they borrowed liberally from the language in our complaint, related it to our case, and are before the same judge, and we're proceeding apace. The cases we usually file, though, are representing independent wholesaler businesses, and these are typically what they call C-store wholesalers. And so these are family-owned businesses that supply all of the goods that you see on the shelves of corner stores. And in that market, Costco Business Centers, a division of Costco, has recently entered that market. Sam's Club has been in that market for a while. And Sam's Club and Costco Business Center I shouldn't say almost always, very frequently get much better prices than our wholesalers get, even though we are selling to the same population of C-stores. So, I'd be happy if anyone is interested to talk about any of the specifics of the cases we've had. But I really came here to continue my quest to persuade people that the common criticisms that you hear about the RPA, they're either just wrong or at least unsupported. Since I'm just a trial lawyer, in the first several years, I was just working on the nuts and bolts of the litigation. But in 2022, I was invited to speak at the Antitrust Committee's spring meeting, and they wanted us to prepare a paper for that. And so I started reading some of the RPA literature in preparation for drafting this paper, and I noticed that these, you hear some consistent themes in all of those papers, and then I also noticed that the papers, they do not really cite any evidence from how pricing practices operate in actual markets. They're based on economic theory, and then also another problem I saw in the papers is that for various propositions, they just cross-cite to each other. And if you follow those citations backwards, you end up at articles by Judge Posner or Professor Hovenkamp the Senior, where they just pronounced that, for example, the RPA leads to higher consumer prices, and then that's been cited 50 times. And I was taken aback a bit because that was the criticisms that we saw in those papers were not, they were highly inconsistent with the evidence that we were obtaining from defendants in discovery. And so I prepared a paper for the ABA pushing back on these criticisms. I condensed it in an article in the spring 2024 issue of Antitrust magazine. And I had expected that that article would take the RPA commentariat by storm. But as far as I can tell, no one has ever read it because I've never I have not received any feedback on that. So with my remaining time, I want to consider with you a couple of the common criticisms, the refrains we hear about the RPA. You'll see these in every paper. And explain why they are just at least not strong, right? So we'll start with the one that I think you hear most frequently, which is that a version of this. The RPA prohibits discounting to large buyers, and thereby it causes consumers to pay higher prices. And now this is just declared as a truism in all of these papers. The Antitrust Modernization Committee, that was a truism. They said, why can we, how can this be tolerated? But there's a fundamental logical problem with that proposition, which is that Section 2A of the RPA, this is the foundational section, it doesn't say one word about discounting. It doesn't prohibit discounts. What it prohibits is price discrimination among competitors. And so the only way we can say that the RPA prohibits discounting is if we assume that the baseline price we're talking about is just whatever the supplier announced as its list price. That way, say if, and I always use Walmart as the power buyer, if Walmart comes along and wants to ask for a price 20% less than that, the supplier says, sorry, we can't do that, this is our price. And therefore, that would be true in that case. Walmart would not be able to get this price, and therefore consumers from Walmart would not be able to benefit from that, and there would be higher consumer prices. But why should that be the relevant price we're talking about? Now, I'm not an economist. I took micro and macro about 30 years ago, all right? But here's what I remember, is that what economists, I think, would call the efficient price is the price that results from a negotiation between a strong buyer and the supplier. And isn't that right? Because I think what we're looking for is to have prices driven down to as close as possible to the marginal cost of production by the supplier, okay? So if we look at it that way, that the relevant benchmark price is the price, the net price that is charged to the strongest buyer. And what we say, the RPA, because again, it doesn't prohibit discounts, it prohibits price discrimination. What can't be done is the supplier cannot discriminate against smaller competitors of Walmart by charging them higher prices. Does that make sense? So instead of prohibiting discounts, what the RPA, another way to look at it that is equally plausible is that the benchmark price is here and it prohibits charging higher prices, discriminatorily higher prices to the strong buyer's competitors. I'm not sure. So another way to look at it, okay? The negotiation between the strong buyer and the supplier results in this price. What RPA enforcement does is a ceiling. It brings the ceiling down to that price and prohibits discrimination of charging this strong buyer's competitors higher prices over that. Now, of course, that's a bit too simplistic, right? If the supplier had to charge everyone Walmart's price, maybe it wouldn't actually be Walmart's price, it would be somewhat higher. But really, if that's the case, then I think the following holds true. When Walmart is paying this price and its competitors are paying this price, the higher price that Walmart's competitors are paying is being used to subsidize the lower price that Walmart is paying. I think that's true. And I guess here's what else I would say is that in practice, in fact, this is exactly what we see that RPA enforcement is doing, what it's pursuing. I've read hundreds of private RPA cases. There used to be a lot, now there are fewer. But in every single one of those cases, what the plaintiff is doing is it is seeking to get the lower price that is given to the strong buyer. I have never seen a private RPA case where the plaintiff comes in and says, we want you to take away that low price and charge everyone a higher price. So don't you see what is happening? If the RPA is enforced, then everyone benefits from the strong buyer's pricing because that becomes the pricing for everyone. And therefore, when we're talking about the benefit to end consumers, it is not only the end consumers who buy from Walmart who benefit from that low price, it's the end consumers who buy from Walmart's competitors who benefit from that low price. And I know there would be some, I'm forgetting the expression that Judge Ginsburg used? Exquisite calculations. This would require some exquisite calculations to really prove its virtue in practice. But I suppose I would end by saying, like, in theory, again, no one has responded to my paper. If someone is interested, I would like to, and I'd be very interested in debating those points as to whether that's true. And again, I mean, we have tons of discovery about what is happening in practice. But I would close with this, and I have more criticisms that I wanted to refute, but I'll close with this. If it is uncertain as to whether my theory, I mean, I think it's probably accurate. Sometimes it's true, sometimes it's not true. Sometimes you can benefit lower prices by prohibiting discrimination. Maybe sometimes you wouldn't. If the evidence is equivocal, then who should be entitled to decide what is best? And I would hope that we would all agree that it should be the people, and it should be the people's elected representatives who get to decide what's best. And not probably 9 unelected people who, footnote, reviewing their biographies, I don't see that any of them has any formal training in economics. And so they would be basing their decisions on 150 pages of briefing, and the briefing would not be submitted by objective people. The briefing is, by necessity, someone who is advocating whatever is best for them in that particular instance. And so, I mean, I do hope, especially with the current Supreme Court, they express all the time their deference to statutory text. And I would hope that they would say, well, these economic policy choices are actually up to the elected bodies. And they passed this act 90 years ago. There's been a whole lot of criticism, but no legislative support for changing it. So, thank you.
All right, thanks, Mark. Alden.
Thank you very much, Bruce. And again, thank you to the Law and Economics Center and the Law School and for sponsoring this tremendous program. I'm going to talk in a little bit about Southern Glazers, but also the PepsiCo case, which was dropped. And so it's sort of a descriptive presentation, and I'll have some normative comments to make later. I'd just mention passing that, back in the early 70s, even the mid-70s, Harvard Law School had a class called the Robinson-Patman Act, which was taught by Philip Arita, famous name, in antitrust scholarship. So it showed how at one time Robinson-Patman was of great interest to students. And who knows if they'll become of great interest again. So recent context, the FTC in December and January of last year voted out complaints against PepsiCo and Southern Glazers for violations of the RPA. Now, the PepsiCo case was brought under sections 2D and 2E of the RPA, which govern promotional allowances. Unlike section 2A, these provisions are often treated as per se violations that do not require proof of competitive harm. Realistically, the PepsiCo case appeared to have a low chance of success. Commissioners Ferguson and Holyoke had stressed the sloppiness of the complaint in dissenting against its issuance. The complaint accused a beverage manufacturer of violating section 2D of the RPA by selling its products to a big box chain at a lower price than it does to smaller retailers, and at providing big box chain with promotions it doesn't provide to other retailers. Now, section 2A of the RPA makes it illegal to, quote, discriminate in price between different purchasers, close quote, which arguably is a clearer characterization of the harm alleged in the complaint than section 2D, which prohibits offering payments or services that are not offered to the favored purchasers' competitors on, quote, proportionally equal terms, close quote. So although section 2D dispenses with section 2A's requirement of showing injury to competitors, both subsections require evidence of disparate treatment by PepsiCo in this case of at least one other retailer relative to the big box chain in question. Now, the complaint cited no evidence of this. Might have shown up later, but there was no evidence put forth there. FTC didn't just face a tough task of arguing a difference in price captured by section 2A is actually a payment not offered on proportionally equal terms, it faced that problem, I think, of showing disparate treatment. It might have been able to do so, but in any event, the FTC appeared to be going into a court, perhaps with very weak evidence that there was any discrimination to begin with. But we never found out because the case was dropped in May 2025. Now, the FTC's case against Southern Glazers, which is going on, is a different story. Now, interestingly, speaking about economics, you have PepsiCo and Southern Glazers, which is the largest U.S. wine and this spirits distributor. So you have complements, soft drinks and booze, Pepsi and whatever your poison is. So maybe coincidental, but who knows? So this was the first government RPA case of the 21st century, but it's sparking private litigation, not surprisingly. Now the FTC alleged that Southern Glazers violated RPA by selling products to small, independent mom-and-pop retailers at drastically higher prices than those charged to large national chains, and favored retailers allegedly receive volume-based discounts and, quote, scan rebates, close quote, reimbursements for price reductions offered to customers that were not justified by cost differences. Now, in April 2025, a federal judge denied Southern Glazers' motion to dismiss, allowing the case to proceed. The court found the FTC adequately pled the 4 elements of a secondary line case. First of all, regarding interstate commerce, the court found that the complaint, which alleged Southern purchased specific products to fulfill the anticipated demand of favored buyers in several states, sufficiently alleged that Southern's goods remained in commerce under a so-called demand planning theory. So no problem in interstate commerce is satisfied. Regarding another requirement of statute, you're dealing with products of like, grade, or quality, the court held that the complaint met this requirement by alleging, 1, large retailers purchased the exact same goods at significantly lower prices than small stores, and 2, small stores and large chains signed contracts that were materially similar outside of pricing. Now, regarding price discrimination between favored and disfavored buyers, the court accepted as sufficient the FTC's allegation that Southern charged disfavored purchasers significantly more than favored chains and aggregated data from thousands of transactions. Fourth, regarding harm to competition, the court accepted the FTC's argument that competitive harm existed because larger favored chains were able to resell products at retail prices that were lower than the wholesale prices paid by smaller disfavored retailers. The FTC also alleged that this conduct occurred, quote, over a substantial period of time, close quote. And of course, this, as seen in RPA cases, the focus, unlike traditional antitrust outside of there, harm to competitors is central, not harm to consumer welfare. And this has already been raised, is a question about consumer welfare, but perhaps it'll come up in our discussion. Now, the FTC, now there's one interesting sideline about this. Liquor distribution is not your typical area. It may be argued, going to a normative point here, that if the FTC is serious about protecting consumers and upholding competition in the market for wine and spirits, it should consider investigating the impact of burdensome regulation that limits competition and leads to higher prices for drinkers without countervailing benefits. For instance, state laws, as well as the U.S. Constitution's 21st Amendment and the Federal Alcohol Administration Act of 1935, require that the supply, distribution, and retail of alcohol all have to be done by different companies. This precludes potentially efficient arrangements that could deliver lower prices for consumers while boosting competition. The mandated 3-tier structure necessitates the very existence of middlemen distributors like Southern Glazers, since alcohol manufacturers cannot sell directly to big or small retail stores. This arrangement does not necessarily make alcohol products safer, and does nothing to mitigate the social ill effects of drinking. And its biggest victims are smaller independent brewers, distillers, and other entrepreneurs who are forced to contract with distributors rather than sell directly to retailers. So again, you think of a Depression era concern about small businesses, maybe not moonshiners, but small brewers, small producers. Certainly they are being hurt. And it's interesting that you commonly hear another normative point that RPA really is trying to protect small businesses. But it's interesting to note, my colleague Satya Marar and I did a study, and it turns out that a large proportion, I don't remember if it was a majority, but a very large proportion of Robinson-Patman cases brought by the FTC were against small and medium-sized businesses. So even lots of small and medium-sized businesses, not just the big guys, got pulled into the maw of Robinson-Patman cases. So I will stop at this point, and I look forward to continuing discussion.
All right, thanks, Alden. All right, so we'll have some panel responses. There's about 20 minutes left, and I'm going to start with Dan. So Dan, in your remarks, you said that you would sort of think about how to do what economists like to do in antitrust, is differentiate between good and bad cases. Indeed, the Republicans who support not enforcing the RPA have some idea of what a good case is and what a bad case is. But how would you screen between them? And maybe you would argue that you can't, and so I'd like to get your reaction to that.
Thanks, Bruce. First, I want to make one thing clear that I didn't make clear in my remarks, but which I think is really important. And that is that the effects of forbidding price discrimination doesn't mean that the high price, a smaller store ends up paying the same price as the larger, lower price store. Okay, what it means when prices are negotiated is that all prices change. Okay, and in fact, in many settings, when there's bargaining over price, if you forbid price discrimination, suppose the big firm is negotiating, the big downstream firm is negotiating. What you do is you strengthen the supplier's bargaining position against the big downstream firm, raising that price, and then if the small firm ends up paying the same price, it's very often the case that both prices rise when you forbid price discrimination. So we can't analyze this by saying, well, here are two prices, a high one and a low one, and if you forbid it, price is going to drop to the low one. Because in equilibrium, under negotiations, things change when you forbid price discrimination. That strengthens the bargaining power of the seller, okay, which can cause both prices to increase. So that's a first point, which I did not make strongly enough. Now, Bruce asked, what would we do if we were going to form policy? And that's a hard question, right? I think an argument can be made that Robinson-Patman, is bad law if the goal is to protect consumer welfare. I think it's generally conceded that pretty overwhelmingly when you incorporate primary line into the analysis, but also if you think about bargaining and how bargaining works when you incorporate secondary line effects into the analysis, that very often forbidding price discrimination puts upward pressure on price. And it can raise everyone's price, and it can raise consumer prices. Even if it raises only the price of the larger firm, the large firm is important, and if you raise that price, that can be bad for consumers. So there's a case to be made for just not enforcing Robinson-Patman as the agencies did for many, many years. But suppose we were we want to try to formulate rules. Potofsky used to say, it's in the law, we should enforce it, and then we got McCormick Splice out of that. we're not going to solve the problem of coming up with rules here. It depends on lots and lots of details about the economic environment. So what I want to do is just give 4 points that are principles, okay, informing the rules. One is that harm to competitors is a very, very poor indicator of the consumer welfare effects of price discrimination. And that point actually applies throughout any trust, not just in Robinson-Patman. A second point is that market structure is a very poor indicator of consumer welfare effects of price discrimination. My sense is in the recent debate, it's more about political economy and market structure arguments, but market structure is a very, very bad predictor of effects in settings that involve vertical issues, and this is essentially a vertical issue in secondary line analysis, right? It's price discrimination across firms with whom the upstream firm negotiates with. And market structure does a very, very bad job of predicting what happens in that setting. A third point is that a per se ban on price discrimination would almost surely have large type 1 errors. And the literature tells us that, and it shows us how and why that can occur. Finally, I mean, a real rule of reason approach to price discrimination requires a detailed understanding of the economic environment. The nature of contracts, are we talking about posted prices or bargaining, the information structure. You really need to answer the consumer welfare question, structural modeling and counterfactual analysis. And people don't like to hear that. That's hard, and it takes a long time, and it requires making a lot of detailed assumptions and doing a lot of what counsel considers arcane analysis. But to get a satellite into orbit, you have to do some rocket science, and that's just how it is. To figure out the economic effects of forbidding price discrimination, you also have to do a little bit of rocket science, and that's just how it is. So I'll leave it at that. People have a little appetite for that kind of modeling, but a basic principle is if you prevent price discrimination, you're restricting the kinds of mutually beneficial terms two trading partners who are complements with each other can agree to. And if we know anything from economic analysis of interactions between complements, it's that restricting the nature of the contracts between them, which are often designed to benefit them both, which often in a complement setting benefits consumers. It's just a very risky proposition.
Right. Thanks, Dan. John, so Maury Edelman, I think you referenced him as an MIT professor, but he wrote a whole book on A&P. And is there good sort of evidence, I don't know if it's causal evidence, about the effects of Robinson-Patman on sort of the grocery store market? I know Dan mentioned, I think, the Ross study, which was an event study, but was there any direct evidence in Edelman's book?
I don't think so. I mean, I think he did point out that the effect of Robinson-Patman Act enforcement was to more likely than not in most contexts to raise retail prices. But it's hard to attribute the decline and fall of A&P to the Robinson-Patman Act. It certainly equalized to some extent the bargaining power between A&P and small grocery stores, but A&P was still a successful company. The postscript, of course, is that the government went after A&P for Sherman Act violations on grounds that seemed to many people then and to everyone now to be sort of incoherent. But it succeeded, and it found AT&T and its top executives guilty of felonious monopolization. And all of that anti-A&P animus obviously had the effect of distracting management, and you could posit a but-for world in which the company would have done better had it not been for those actions, but that's a bit of a stretch. The reality is that A&P faced a lot of competition from other big supermarket chains like Kroger and today Walmart. We have a lot of competition in the provision of groceries, but the lowest prices are the ones that you can obtain in places that have the largest scale. Robinson-Patman arguably has the effect of keeping the prices at those stores a little bit higher than they would otherwise be. If I could make an observation about the institutional dimensions of Robinson-Patman enforcement. Mark pointed out that we are a nation of laws, and Congress did pass this law in 1936, and it says what it says. It's interesting to contrast what the Supreme Court has done with this law in the context of primary line jurisdiction, with what primary line discrimination, with what is done in the context of secondary line discrimination. Primary line, well, that's Brook Group. And in that case, the Supreme Court basically, as far as I can tell, didn't really analyze the text of the Robinson-Patman Act in concluding that the right focus is on consumer welfare and that the act is consistent with the principle that we protect competition rather than competitors. In Volvo, though, the Supreme Court maintained the pro-competitor orientation of the Robinson-Patman Act with respect to secondary line discrimination. And I think, that is the appropriate thing to do. I mean, you may hate this law, you may hate its welfare effects, but you shouldn't be mangling Congress's language in the course of doing that. And I think that's also what motivates the current FTC chair, Andrew Ferguson's observation before he became chair, that he may not like the Robinson-Patman cases that Lena Khan brought at the FTC, but on the other hand, this is an act of Congress, and the executive doesn't get to pick and choose among the acts of Congress that it duly enforces. Now, a couple responses to that. One is he made those comments in 2024 before President Trump actually took office. And I do not think that it is really the policy of this administration to enforce all of the acts of Congress that come before the administration for enforcement. In fact, he's purported to cancel some of these statutes. But Andrew, nonetheless, is correct. We should not be nullifying acts of Congress. I don't think, though, that you need federal enforcement to give effect to the Robinson-Patman Act, because you have people like Mark who can sue on behalf of private clients and effectuate the basic purposes of this act. So I don't quite understand why it is necessary for the FTC or DOJ to allocate scarce resources to enforcing a law that it thinks has anti-consumer effects in most cases, when it could be spending those resources to prohibit real anti-competitive conduct.
Yeah, I just add a comment. I agree entirely with Jonathan, but one, Commissioner Ferguson himself has said that, we have limited resources, and there is such a thing as prosecutorial discretion. That's part of the common law system we have. So the question really is, the FTC has said it has limited resources to enforce the antitrust laws. If you can, arguably not enough resources to bring all the cases that seem likely to show clear consumer benefit. So it's perfectly rational and justifiable to focus resources on non-RPA cases if you think the likelihood the non-RPA cases are going to enhance consumer welfare is almost always higher than the likelihood that RPA cases would. And as was suggested, leave it to the private bar to continue enforcing RPA.
All right. So Mark, Dan and I are both economists. So I think Dan's remarks on that he just made really were about equilibrium prices. And Dan said, well, how would economists actually figure out what the effects are beyond theory? And there are two ways in antitrust we do it. One is we do retrospective or event studies, right? So my big hope is California, what's next for the Cartwright Act? They basically go wild hog and say at the state level we'll have, a very strong, not RPA, just no, just no price discrimination, and we could see what happens in California relative to other states. That's one. And the other way that we would learn is structural estimation and maybe simulation. I mean, there has been some economics that illuminate what happens. First, there's a whole bunch of studies, one by Hausman and Liebtag that's pretty well known, about what happens when Walmart comes in. And when Walmart comes in, it's not a direct test of, intermediate good price discrimination, but they're, as you well know, they're getting all kinds of volume discounts and various types of promotional payments and payments for the end cap and payments for the shelf space, and the evidence is that prices where Walmart comes in, so that would be a natural experiment, go down. The mom and pops get hurt. The chain stores like Kroger get hurt, right? And how does that square with sort of your notion that this is going to potentially hurt consumers?
Right. So thank you for bringing that one up. So that's not a natural experiment about RPA enforcement, right? So in a world of RPA enforcement, if, under my model, remember, the baseline price isn't the announced price, it's the price that Walmart negotiated. If the existing groceries in that town were, by a prohibition against price discrimination, entitled to Walmart's prices from their suppliers, then all of the prices in that town paid by all of the consumers, regardless of where you shop, would decline, directionally at least, right?
Well, but Walmart, I mean, Dan's point was that Walmart's price, that idealized price or that strongest buyer price would go up. I mean, that's sort of the equilibrium analysis that
I agree. We don't know where it would fall, right? But by saying that when Walmart enters a town, consumers pay lower prices and Walmart's competitors also reduce their margin, and that means that we should allow price discrimination. It doesn't follow that means that we should allow price discrimination.
Right. There's actually
if I could just chime in here, it's just really dangerous. I see this all the time in antitrust. When we analyze, effects of things, we assume certain things are held constant that are not held constant when you change the policy.
Yeah.
So that's a very large mistake in trying to figure out the effects, the equilibrium effects of what happens when you change a policy. So there's no way to analyze the question without figuring out what would happen to Walmart's price. And presumably the other folks would end up paying the same price as Walmart if the statute were enforced. But you have to do that to figure out the effects on consumers.
Yeah, so there is actually a study by 3 French economists of a 2008 French law, which they had a ban on differential pricing by branded goods, but not sort of the private labels. And they lifted that ban, and so that's one event study. That I think the control group's a little bit problematic. But are you familiar with the study that was by a seal that was cited by the FTC in Southern Glazers or?
I don't speak French.
Yeah, that wasn't French.
No, I am not familiar with that.
But,
look, I'm not a scholar. I'm just a practitioner.
Yeah.
As Phil Hartman said, many will remember, I'm just a caveman lawyer. Unfrozen. So,
yeah. So, I did read your article. I think one of the things that really should be done is, finding some experimentation. And I agree. The Walmart thing, as I said, is not an event study on price discrimination. But you do see sort of the effect of that. And, maybe, California, my home state, that's where I was born and grew up, I'm hoping that they do a lot of social and economic experimentation there. And I would encourage anybody who's in California to say, let's have really turbocharged Robinson-Patman apply.
They already do.
Yeah.
You might not be surprised.
Yeah,
Right?
they already do.
We bring those alongside ours, and
Yeah.
we won that at that Clear Eyes case.
Right.
But no, I mean, maybe not turbocharged, but similar.
All right. Alden, why don't we go to questions? We only have 6 minutes before lunch. So Dan, and I'll right there. Yeah.
Thanks,
Yeah,
Bruce. Dan Gilman, ICLE, and maybe this is a question for the panel or the economist. So, I mean, Bruce, you sort of introduced the idea of an event study that's not directly a study of RPA itself. I mean, it's not a huge body of literature, but there is some empirical literature in the healthcare sector on things like, freedom of choice and any willing provider laws, including, I think, a couple of papers by staff who worked under you at FTC. And so, right, that's not a study directly of the effects of RPA, but those studies, I think, do bring under suspicion some of these provisions that have occurred in state law and even CMS regs that have limited or restricted price differentiation, I think really pretty much in the way that Mr. Poe suggested, namely, the small players can come in and get the same deal that the big ones did. I don't know if people have comments on this literature.
I mean, yeah, you do sort of, you rely on the event studies when, of course, even if you sort of relax Mark's notion that the Walmart price doesn't rise or rise much, right? There are winners and losers. I mean, the traditional final goods price discrimination literature says that they're either winners or losers, except in the case when you serve in a previously unserved market. Then the existing price doesn't change, but then you get higher welfare. But even in the case where both prices change, right, there's winners and losers. And so the welfare effects are, as Dan said, ambiguous, right? Yeah, but I think, one good thing would be if we had some experimentation, or maybe if Mark brought a lot more cases in California. And, but we would like to, I mean, I don't know if the Clear Eyes case comes out, maybe we could, look to see what happens downstream, not just what the prices you saw in Discovery, but encourage some people to sort of look at equilibrium, what happens after.
Let me just comment quickly on that question. If you have experiments or studies that are not quite, the exact experiment you want to run, you can learn things about, what economists would call structural parameters, which just is sort of, jargon for how things work. And then you can take that information and then you can do the correct experiment. And try to predict what would happen. Maybe we need some graduate students to try to pull together, a bunch of studies of things that look sort of a little bit like, an experiment that would have some information that we could use to think about the Robinson-Patman Act, even though they're not the exact experiment we need.
They're actually...
And I agree with Bruce that, if California runs this experiment, that would be great. Well, they're running it.
There actually is an unpublished paper by a guy named Hageman. He was like a Bob Town student. In Connecticut, he used some sort of a variation to estimate a structural model, and then he simulated what would happen if you made the prices, after he got the demand and cost parameters. He never published this study. He went to work for some tech firm, and I guess, you're not a professor, so you leave your stuff laying there. But yeah, people have done that. What that really doesn't get at is sort of the notion that people are worried about sort of longer term effects than sort of, stable demand and cost parameters and stable sort of sellers in the market and you get exit. And so, but he finds that, his simulated prices, and it was alcohol, would net go down to consumers. Okay, we have time for one more in the back.
Hi, Chris May with MLEX. Thanks for the conversation. My takeaway from this panel is that this law has been on the books for almost a century, but there's no conclusive empirical economic evidence that it's either good or bad for consumers. So I was just curious what each person on the panel thinks is the strongest empirical evidence for Robinson-Patman enforcement, either improving consumer welfare effects or the opposite.
This may not be a direct response, but there are a couple of studies out there. For example, Commissioner Bedoya said there hasn't been any empirical work. Well, there are, for instance, there was a study by Hausman and Leibtag that found Walmart's expansion into grocery retail increased consumer welfare by over 20% through discounts received by Walmart passed on to consumers. And there were studies by Kurt Malch and others finding that competition from Walmart and other large retailers resulted not only in lower prices, but also in significant reductions in food insecurity. Now, of course, Robinson-Patman was in effect. So you might say, well, that doesn't prove anything about Robinson-Patman. But I think it goes more to the big picture question about wanting to incentivize these large, lower cost retailers to enter and to benefit consumers.
Well, I see the stop sign, and it's lunch, so I think we're going to have to stop. Let's have a round of applause for the panel.